So obviously, insurance kit, that's me. And I've been in the business for about, I'm going to age myself, obviously, about 20 years now, just a little bit short. Ivan has a little bit more experience. I will introduce him a little bit later. And I really enjoy the business because I really feel like this is a calling, to help people when they really need it with insurance, especially when there's untimely death. And I've been doing it for almost 2 decades now. And in why you might think why we'll be talking about the will, and obviously insurance is paid out when someone passes away, for life insurance, but there's also other insurance that will take care of you while you are alive. But tonight we're going to focus on what happens to your properties when you die. Now, Ivan has, like what I said, have been over 20 years experience being a real estate law, estate law and wills and business lawyers. And he not only that, he's also a very great supporter of the theater community. And because some of our guests tonight actually signed up during the play that I was in on Sunday. So yeah, if you're a theater goer, then you will appreciate, because all the productions out there need sponsors, and Ivan is a great sponsor of the theater community. Not only that, he also actually do radio shows on Fairchild Radio. And Ivan, do you do CHMB as well, or just Fairchild?
CHMB 1320 legal hotline. Sometimes once or twice, once every 2 months or so, that on the legal hotline show, Saturdays at 4 to 6 on 1320.
Okay. Oh, so not Fairchild. Sorry. So it's only CHMB. Okay. Yeah. So if you after the webinar, if you do need to ask more questions, feel free to reach out to Ivan. Very easy to find him on Google or with the information. So without further ado, I will let Ivan take lead into telling you what happens to your property when you die. Thank you, Ivan.
Thank you for the nice introduction, Kit. And as Kit had mentioned, that I do a lot of seminars and also radio, but they're all on my YouTube channel. If you ever had a chance, just type Iven Tse on YouTube. And a lot of my shows and podcasts are uploaded to YouTube. So like and subscribe and can continue on and do more stuff. So a little bit about myself again, like I do a lot of real estate, I do a lot of wills and estates. So especially when it comes to estate planning, for a lot of my clients, they have properties that they want to give to their children, how to do it, how to avoid taxes, how to do it with least amount of problems and complications, and how to do it most efficiently, avoid, children fighting and things like that. So I deal with that kind of an issue all the time. There's different ways to it. Today, I just want to talk a little bit about how things will happen if things were just how where assets will go and how things are held, and talk a little bit about that. As it goes through these topics, questions come up to mind. As we mentioned, put it on the chat line. We have some time at the end to answer some specific questions. Okay. So this is myself here. This is my contact number. If you want to text me, call me. My WeChat code is on this screen, but you can always scan it and go from there. Okay. First thing, I want to talk about how property is held. There's different types of ways in which property can be held. The most common ways to refer to it is property held as tenants in common or as joint tenancy. And different kinds of properties are held in a different kind of a way, okay? And I really want to talk mostly in this sense about real estate, but there's other things too. But it's just some definitions, first of all. If anyone has property and it's registered in more than one name, then there's 2 ways that property can be registered under: tenancy in common or as joint tenants. Now, if you don't know how your property, your title is held, it's worthwhile to, spend a long time, take a look at that title search to take a look at it and confirm what it is. You can find that out in a tax search. You can only find that out in a title search. And if you've lost it, you can contact me. We can give you an address. We can do a search and then tell you what it is or not. Okay, now a little bit what that means. Okay. Joint tenants means that survivor, there's more than one person. So let's say there's two and one person passes away. The survivor can inherit the other person's share, the person who passed away, without having to go through a probate procedure. And this mechanism is called the right to survivorship. You guys heard of probate procedures. It could take a long time. It costs money. You have to pay probate fees. If the title is held as joint tenants, then there doesn't have to be that procedure. You don't have to go through that process to transfer that asset to the other, to the survivor. Okay. That's opposite of tenancy in common. If you hold that property tenancy in common. Now, if you happen to pull out your title search, as I mentioned that, and you say, hey, it doesn't say the words tenancy in common. Well, that's the thing in title searches. If it says joint tenancy, it's joint tenancy. But if it has no mention of that, it's blank, it's empty, that it means by default tenancy in common. Okay, means that the share held by the person holding that tenancy in common interest can only pass that interest or that portion of the property through a will or through a probate process. And if there is no will, call it administration. So, it's called a probate if you have a will, administration if you don't, but the same procedure, it still applies. And I'll talk a little bit about that later on in the program. Okay. So next thing, now on title on real estate, people can more than one person, like 3 or 4 or 5 people can own properties in different ways. So this is an example that I put up here. So you have 4 owners, 2 of them are husband and wife, 2 of them are friends. They all put their money in together to buy a house. You can have the husband and wife's 50% share held as joint tenants. So that one husband passed away, transfers to the wife without having to go through probate. But their 50% share can be held separate from the other 2 friends as tenancy in common. So that way that more than one person can be on title. However, the shares of one chunk, if it belongs to a family like a husband and wife, can be kept inside that unit if one of them should pass away. Okay, that becomes important later on when and if parents are transferring property to the children, they stay on title. Maybe the child has friends and they or common law spouses or girlfriends or boyfriends. You might want to think about different ways of owning property on title when and if that happens. Okay. Now, there's a question. I wonder if now that you know that there's something called a joint tenancy in real estate, and what happens if both people that are holding a property as joint tenants passes away at the same time? Now, like there's no polling system here, but I just want to say, does anyone know what happens? Does it how would anyone know? You can't go to either person because both person has passed away. In that situation, the BC law, they treat it as if the 2 people that are holding as joint tenants as if they were tenancy in common. So then they still need a will and have to go through probate in order to transfer that 1/2 share to anyone else. Okay, so that's something to know. About 2014, prior to 2014, this rule was not there. It had changed in 2014. Now, a lot of people who perhaps have had their estate planning done before 2014, including doing the wills and including doing their estate planning, you might want to look at over again and have it reviewed because the laws changed and presumptions had changed back then. So a lot of the presumptions and rules have changed, and this is one of them. Before 2014, if both person passed away, it's presumed that the older person passed away, so it transfers to the younger person. Okay, so that changed. So if you had wills done and estate planning done before 2014, this is a good time to review it. To make sure it still fits into whatever you were planning at that time. Okay, so the family home, this is the biggest issue right now. I have so many clients of mine. They're downsizing, they want to pass some property to their kids, but they're worried about how things get protected and how things will go. And I just want to talk about how things can be done. Okay. Now, one of the biggest questions is, a request is, can I add my children onto the title of my property? If I pass away as have joint tenancy, then I don't have to go through probate, don't have to pay probate fees. And there's a land title process and the title gets transferred to the children. So here's some things I want to talk a little bit about that. Okay. First of all, what are some pros and cons? What are good things and bad things? So If the children are living on the property at the same time as the parents and they pass it to the children, great, there's no capital gains because this is considered an investment home. It's a family property. But for children who do not live in the family home, quite often this happens. The kids have moved out. The parents want to, thinking about estate planning, want to transfer to the kids. But if they add their names, the kids' names on title, their share or the portion that they hold is going to be considered an investment property. So when the house is eventually sold, the value that's increased from the time of the transfer until when the house is sold will be treated as capital gains for the children who do not live in that property. Okay, that's important to know. But the other thing too is that like another big question that comes up is, well, the parents say, hey, if I add my kids to title, then what if I want to do something like I want to change the tenants or the downstairs unit, sign a contract. What if I want to remortgage the property? What do I do? Then there's an issue and a question and a problem, there's always a way. And one of the things that come up is for parents who want to continue to manage, just have the children sign a power of attorney to help manage the property to the parents. So the children can delegate their powers to the parents. And the parents can continue on managing the property as if it was their own before they transfer the property. So there's always that question, and how do I do this? And what if I want to do that? You can always do that, okay? And the other question that comes up is what are the potential savings by doing that? Well, I mentioned about probate fees. So the other thing about adding children entitled to the family home, if it's the parent's home, and there's no property transfer tax. There are some exemptions to property transfer tax. This is a tax 1% of the first $200,000 value of the property or share of the property being transferred, 2% up to $2 million, and 3% over $2 million based on the value of that share. So, but there is no tax if it's from children to parents, parents to children, grandparents to children, or grandchildren. So literally up and down. But there will be property transfer tax if it goes from sister to brother, uncles and aunts and nieces, nephews and nieces. But from grandparents to kids and kids down to grandkids, that kind of a transition, as long as the home is lived in by either the parents or the grandparent or the child living in it or the transferee, either one, then it's exempt from this property transfer tax. Okay, you save that. Now, the thing about sometimes about why is it? Because it's quite a lot. Like in terms of 1% of the first $200,000, $2,000, 2% of the rest. So if you look at like $1 million house and 2% of $800,000, and you're looking at like it's quite a bit, and you add that $2,000 on top, and then it's expensive. Plus, you have to think about if and when you do the transfer of an investment home, then you have to add think about the capital gains later on down the line. There's a lot of cost involved, but most important people do this is because of probate fees. Not only the saving the property transfer tax now when you do the transfer, there's no probate fees because the transfer to the survivor will happen through the land title office and some transfer document, and it transfers to the survivor. There's a registration of a death certificate and a few forms, and then it's automatically transferred without having to go. And it could be done within a couple of weeks, all done without having to wait for months and to pay for probate fees as well. Okay, so that's why some people think, oh, that's a good way to do it. Now, there's other properties besides real estate, joint bank accounts. So if you add children onto bank accounts, or if you happen to already have bank accounts that are two names or more than one, or with the children, these kinds of accounts operate just like a joint tenancy. They transfer to the survivor, the person who's still on the account, without having to do anything. You don't have to go through probate to automatically have access to that extra amount of cash if it's held jointly. Okay. Now, things other than bank accounts, there's a lot of things such as TFSAs, RESPs, registered investments. These things have a function, like all of these plans have a way in which you can pinpoint or designate someone to be the beneficiary. You designate them. And if you never was asked that question and you never thought about it, it's a good time to ask your financial advisor, someone who buys them for you, to say, hey, do I have a designated beneficiary? The thing about that is once you designate a beneficiary under these plans, it doesn't go through the probate process anymore. The only time it may will is if the person you chose is also passed away. And then the funds have to go somewhere and it goes into the estate and then you have to pay that. But in the meantime, well, you can still choose. For example, designate a couple of children under your different plans. You can have one plan choosing one beneficiary and then another plan choosing another beneficiary. You can have a TFSA that has two beneficiaries, so you can do that and mix and match and try to get the all of the if you're thinking about equality, so you can match the fund with the person and which the child that you want to give and have that all done. Okay. Now there's other things too, non-registered assets. There's things such as life insurance and segregated funds, which annuities, which Kit is the best person to tell you about these kinds of options. And I don't talk about this in this whole program, but one of the most important things that people always tell me or they ask me when they're doing planning is they don't want their children to fight. Give one something more to one, and maybe it's not equal. One person needs more, the other person needs. What I tell them sometimes is, well, you can choose to have assets given not through a will. So you have plans such as TFSAs with a designated beneficiary, but life insurance, really good thing. You can't really fight or challenge life insurance. Kit would be the best person to tell you about that. And I give you at this point a little segue in terms of this kind of a thing where I had a client brought in by his 6 kids one day. They all sat around the table and the dad, he's looking at the kids. Well, you brought me in here. I finally have to tell you. And he points to the youngest one, no, the oldest one in the corner and says, when you were 1, me and your mom, we had a falling out. And during that time, I had another kid, had another relationship, and she lives in Brunei. And so since I'm giving you each a house, I'll give her one too. It was like, everybody is like, oh, and I told all the kids to leave the room, and I talked to the guy and I said, look, if you give a house to someone overseas, you're looking at foreign buyer's tax, 20% tax on the value of the home. Then you're looking at someone who doesn't live here. Maybe his house is empty, the speculation tax, and then you have the vacancy tax if it's in Vancouver, So why don't you do this? Go to Kit, buy life insurance, and the money goes, and you don't have to worry about property transfers or anything like that. And then the kids, he agreed to that. The 6 kids that live here in Vancouver, I said, thank you, goodness. And then then everybody's happy. Okay, and there you go. Just a little story about that. Okay, I did want to tell a little bit about wills and probates in terms of the procedures and what happens if you don't have a will, what happens if you do have a will, things like that. Okay, so first thing, some question. Assets held as joint tenants, of course, I just mentioned. None of those things, designated beneficiary, assets such as TFSAs that have a designated beneficiary, they don't go through a will, so it doesn't get probated. There's no probate fees on that. But here we go. But what happens if there is no will? Okay, so common situation. I want to have a situation. There's a husband and wife, mother and father. They have a couple of kids. What happens if they pass away and they have no will? Okay, so this is the first important thing. If there's a spouse and the children belong to the couple, the children, the 3 kids that I mentioned, are the actual blood children of the father and mother. What happens is there's a preferential share, 300,000 is specified to be inherited by the spouse. The balance then is divided half to the spouse and half amongst the children. So the idea is sometimes, all of it goes to the spouse. That's not true. Just the first chunk, and then a half of whatever's left. That's the situation if the children are children of both the father and the mother. Now, another situation that happens if, there's children from the spouse has remarried, and there's children from the previous relationship. In this situation, the spouse who's not the blood father or mother of the kids, they get a preferential share of 150,000, so half, and then the rest is half between the spouse and half between the children. Now the question sometimes comes in, well, what if they only had 150? What if the assets are only 300? If that situation happens, the children go get nothing because that's all the state has, and they're the first ones that get priority, and then nobody else gets priority. So if that happens, then the children get nothing, and the spouse gets everything. Okay. This is like, if you
Ivan,
don't want that situation to happen, this is why you should need a will. Yes, Kit.
So I'm the host, so I can break the rules that I said.
Oh yeah, of course, anytime.
Sorry, the spouse that you were talking about in the previous slide are you talking about the new spouse or the old spouse?
The new spouse, yeah.
The new spouse, but I guess the old spouse doesn't get anything because
they're
divorced already.
Yeah, exactly.
Okay.
Yeah. There is a situation. I remember, like, I had a client that helped with the immigration sponsorship. He's from Dubai, so we finished his first wife's application, but I didn't know his. And then he said, "Okay, finally finished with this first one. Now let's work on my second one."
They probably have 7, like
sorry.
more coming.
Immigration forms, they only ask, have you been previously married? They don't ask if you've been married after. Oh my goodness. Anyways, the unknown things. Anyways, yes, you're right. So it's on the presumption that the previous spouse has either passed away or divorced, and his remarried situation, which happens a lot nowadays. So there's a lot of those questions that do come up. Okay. Now, if there's no spouse and no children, the estate is distributed to the parents. So the way the Wills and States Succession Act, which is a law, tries to go down the ancestral level, if it can't go further down, like kids don't have no kids and no great grandkids, then it goes up one level to the parents. If there's no parents and it goes down one level, do they have other kids of the parents, which means the siblings of the parents, and then for the kids, then it would be considered like their nephews, uncles and aunts, and if there's no uncles and aunts or siblings, then it goes up one further to a great grandfather, then goes downwards to kids, and then down. So this is how the distribution works. Okay. So no surviving parents nor descendants of the parents, then the estate is divided among surviving grandparents, and then it continues like 4 different levels of finding ancestors. Now, before 2014, it wasn't like this. It would just keep on going until it stops. But there's 4 levels, 4 different levels under the Wills of State Succession Act before they won't bother having anyone else being entitled. So you go up to the great grandfather's side and keep going down, and you won't keep on and on until they find the last surviving kin. It's not like that anymore. Okay, you go 4 levels up.
That's why we hear news every now and then, right? Oh, someone is actually the descendant of like King Henry or something that I read about in the news, right? I guess they just keep looking, right? And then finally the guy will be the lucky one.
It happens in those movies, but in BC it doesn't happen here. Okay,
no, I think it's in UK. It's real life. Like the guy was like related to some kingship, some king in the past.
You can find it, search it, tune it, the DNA test, and you go, ding, you are. I'm related to the king.
Yeah, that's right.
Oh yeah, you hear that. You see that in movies quite often. That's true. Yeah, but anyways, in BC it stops, and then it goes to the government if you can't find it anymore. Okay.
So it will actually goes to the government's coffer.
If you can't keep on continuing, it has an endpoint. It doesn't just keep on going on and on and on. That's in BC. Now, it's a good segue to say that in every province, the wills legislation is different. It may be different anywhere else. And of course, any country is different. Hong Kong is different. China is different. US will have 51 different ways of doing it. So you got to check every single one. If you have assets someplace else, make sure you know about that other place and how estates are done in that other place. Okay. Now, there's another thing I want to talk about is the spousal right to buy and keep the home. The surviving spouse has the right to acquire the spousal home. Now, this is a situation that quite often happens if the home is in the name of, say, for example, and this happened was an exact case that I'm working on right now. The husband or the wife, and the wife is a second wife, and the husband has kids from another relationship, divorced or widowed, and then the guy has a house, but they live in the house. So after the husband dies, it's under his name. Now normally it's under the husband's name only. It'll go through his will. His will might say everything to my kids, etc. But if he does have no will, then there's this not only the preferential share that we mentioned before, but the spouse has a right to the home, to buy the home or take the home. So she doesn't have to leave or sell, have the house sold and move out of the house if the kids don't want it. The kids want it back and they can't kick her out. She has the right, he or she, and sometimes I have to be careful about the gender pronouns, but he or she, the spouse, yeah, they have the right to buy the home. Now, if they're given their preferential share, the 300,000 or 150, it could be part of the value of the home that they can use as a way of buying the home and pay the balance back, and the rest of the money gets divided to the other kids. Okay. This is something because quite often, they lived in a home for maybe sometimes 15, 20 years, and this is their house that they grew up together in. It shouldn't be that as soon as the spouse whose name was on title dies, it goes to the kids, and she doesn't get a share or even get a say in doing what she wants to do. I want to live in this house. I want to keep the house. They do have this legislation right in the Wales Estate Succession Act that allows that to happen. There's a time frame though. She has to make this purchase no later than 180 days now after the grant of administration. So a grant of administration, if someone has a will, is a grant of probate if they do. So if they have no will, then there's the time frame. There's a limit, and they can exercise this right. Okay. So that's something else. And now I just want to talk about. Oh,
Ivan, will that be who determines the price of the home?
well, quite often it's the most common way is getting an appraisal.
So
Now,
the spouse will have to buy it at market value.
yeah, exactly.
Ooh.
Yeah, you can use a common like the BC assessment, and that is quite common if the children have no qualms, and this is the exact same situation that I had, that if they did an appraisal, it would be more than what the BC assessment was, and they all agreed on the BC assessment because in that situation that I'm talking about, the three surviving children of the father, they actually like their dad's second wife, and they appreciate how she helped, and they didn't want to challenge and get a higher value to get more, make her pay more. So they're okay with just the BC assessment value. And if they don't, and there's a dispute, then quite often what happens is the people who dispute it will do an appraisal of theirs. The spouse who wants it would do an appraisal of hers, and then they take the average. One's a little bit higher, one's a little bit lower, put it right in the middle. That's a common way to do it. It's a common way in which lawyers will negotiate it. Sometimes we have parties and we talk about it and we negotiate and we end up with a compromise sometimes like that. Yeah, it's quite common. So I want to talk about the process. We talked about probate, how much it, and how long it might take, a little generally about how much things cost. I want to talk about it more in detail. First of all, what is the process of probate? What happens? How does how in which properties get transferred over to the next generation? Okay, so if there's a will, then it's called a probate, and this process is very similar if you don't, but I just want to go through this one if you had a will. So the first step to do when the people who are helping, who have been appointed as executors, someone's passed away, there's a will, the executor has to search to see if there's any other will, anything else written that may look like a will, act like a will, and has things in it that seems like it's a will. Because in BC, they allow documents that seem to be like a will be the will if there's nothing else, So it could be a whole bunch of memorandums and notes scribbled down and signed someplace else, put it all together, that is the will. They allow that to happen. But so they'll search. So one of the first things to do is to check with the wills notice registry at the Vital Statistics Office. You can always do this online. You go to Vital Statistics and pay a fee and search the name and see if this person with this birth date has ever done a will. And normally, and I do that as a normal practice when I do wills for my clients, I register the will. The copy itself is not given and registered anywhere. It's just the name, the person who did it, and when it was done and where it's kept. So if you had a will in your hand and you wonder, well, is there another will, and you do a will search and it notifies that there is a will dated later, then the one you have in your hand is no longer valid because most wills revoke the previous will that was done. So that's important to know. And it happened exactly one time that I had a situation where my clients brought in a will. We did a will search and found out that there was another will in the safety deposit box in the Scotiabank over by Commercial. And oh my God, and it's later. So
Mm.
what was changed, and then the guys, they don't know where the keys was. They had to like drill in the box and open up the box and find the will. I was like, oh my goodness. Anyways, you need to know, find it, look for it, see if there is. No. The next thing.
Ivan, Olivia has a question.
Yeah, sure.
Olivia, go ahead.
Yeah, so those will that I put away in my cupboard or something like that, that is not officially signed or seen by the lawyer, are those considered a valid will?
And whether a will is valid or not, it depends on me taking a look at it and telling you if it is. Is there two witnesses? And sometimes a will may be valid, but it's ineffective. Like, for example, I've seen wills where they say, I give my house and everything I own at this address to Joe Blow and Jane Doe. But by the time they pass away, that house was already sold. So, yeah, it's valid. It's witness, right? And, you have the right thing, or you have the right name, but the contents are kind of like, well, what happens now? So, yeah, so it really depends. And if you haven't had someone look at it, it's good. Like, it's okay to do your own. And I don't, that's why, they have a thing in the law that says things can be like a will, can't be a will. But it's better to have someone who knows what they're supposed to look like and what's supposed to be inside to have a look. Okay.
I do have a question now. So if I have my own will, I did it on my, Word document, I have a witness signing them, and but I didn't get it notarized, or I didn't bring it to a lawyer. That's still okay, right? But what's the point of notarizing a will?
Yeah, so the idea of like first of all, yes, if you've done your own thing, it's okay. You followed all the rules about in the kit, the
will kit,
the will kit. Yeah, listen to the insurance kit. So the will kit, and they follow the rules, and then you done it and you put it away somewhere. Now the idea about notaries and lawyers who do wills. So one of the obligations and requirements of a lawyer and a notary is to identify the person who comes into the office as a real person. And also when they sign it, they're witnessing it, in the sense that if there's ever a question about someone forging a will, if there's ever a question about someone pretending and writing something down, but it's really not that person, they really don't know who that person really did write it or not. And was it, someone forged their name and changed it, something? And that's a risk that may happen, because it could be challenged by saying that's not her will and that's not his will, that's the different handwriting, et cetera, et cetera. There's one level of uncertainty removed because lawyers have an independent obligation to verify identification of the person signing. And plus, normally the lawyer signs as a witness, and we keep records of it. And if we see something that someone says, this is the will that was witnessed by Ivan, I look at my records, that's not the one. That's not one that I witnessed, because my copy is not the copy that the person had in their cupboard.
Thank you.
And then that's one of the key things, and validity and removing a source of challenge. Now, I do have I think somewhere in one of my YouTube channels, I have one segment where I talk about 9 different ways to challenge a will, and that's one of them, right? So it was not the person who actually wrote the will.
Thank you. That's a good information.
Yeah. Does that answer your question too, Olivia? Yeah.
Yeah, thank you. Yeah.
Okay. In terms of the probate process, the second step before looking for things that can be like a will, its second thing is to search for assets that gets distributed under the will. So you search around, you find bank accounts, you search around, you see bank cards or credit cards. So there's not only assets but also debts, if you don't mind me saying on top. You search for assets and debts, anything owed, lines of credits. You look at cars and jewelry with appraisals. The reason why you need to do this is that quite often all the assets need to be put inside an affidavit that gets brought and filed with the court and stamped with the court. If later on you find an asset and you want to have it transferred, say, for example, the bank account, the bank will say, hey, give us the copy of the affidavit that you signed confirming that this was a bank account that was to be transferred. And if you don't have it listed, then you have to go back to the court, refile an amended affidavit, and maybe pay a little bit more probate fees in order to get that thing done and transfer. So you have to have a good list and accurate list to transfer everything. Okay, so you take a couple of weeks to get the will search done. You take a couple of sometimes the thing about assets, why it takes a long time, I wrote down here, normally takes 2 or 3 months, is because sometimes you not only need to find out what that asset is, you also need to know the value as of the date of death. Okay, it's not like 2 months later, the date 2 months later, it's the date as of the date of death. So quite often this requires letters and documents and authorization forms sent to the banks. And the banks will eventually get around to giving you a value and a letter saying, in our bank, we have XYZ bank account, XYZ mortgage, XYZ investment account, and all which is worth X at the time of death. And so it takes time for these banks and organizations to give you the figure that you need. And it's different than if you have a car. You just go look at the blue book and online and value of car, 1967 Chevrolet, blah, 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 and then put the values down. Okay, so but quite often that process takes a long time. Credit cards, the date in which someone passed away, how much is owed. Okay, you need to put all that in, get all that. Now, another process is called notice to potential beneficiaries. So an executor is appointed, he applies to the court to be the executor, give the grant of probate to him and the powers. He has to notify all the beneficiaries under the will and potential beneficiaries, if there was no will, to let them know that he or she is applying, because there could be a challenge. Okay, so there's a time frame to notify everybody and make sure that everybody's notified and confirm that they've received the notice of application. Okay, so it takes time. It normally takes about a month to do this. And then for myself, once all steps 1 to 3 have been done, then it's up to the lawyer's part to doing the probate, to put all the documents together, have the clients come in, the executor to sign all the affidavits and provide all of this information to the court. And then it takes about a month or 2 to put everything all together and get it all signed. And then everything gets sent to the court. Now, once it's at the court, it takes 3, sometimes 6 months, sometimes more. The courts will look at everything to make sure it's all right, and then come back with a calculation of how much probate fees need to be paid. Probate fees are about 1.4% of the value of the entirety of the estate. So they value it and then give you a number. They give me a notice. I let the clients know, hey, probate fees are whatever $1,000. Bring me the bank draft or certified check payable to the Minister of Finance. Bring it to me, then I submit it to the court. And usually about a month later, I get the probate. The grant comes out. Okay. Now I'll give you these approximate but they're, don't take my word, because quite often the court process and, there's shutdowns and then there's delays and things just take time. Okay. And
I also heard that some lawyers don't even look at it for at least a month or 2 before they actually start looking, because they're so backed up. So
yeah. And then they don't bother looking. If not, don't check every day. What I do is I have an agent that goes to the courthouse every day, check the box. No, nothing for Iven. Nothing for Iven. So I don't check myself, but I have people checking there. And once they see it there, okay, then they send it to me. So
good.
Yeah. So but it does take time. And during COVID times, and I don't even bother giving estimates at all, period.
For 2 years,
time, whatever time it takes is the time it takes.
So I just did a quick calculations from all the time frame that Iven had. So it's about 14 months. So that's why when I tell clients as well, on average is 12 to maybe 18 months, right? So so that's pretty good.
It's kind of fills in the gap. And people wonder, how come it takes so long? Well, then, there's 101 things on each of these things that make it longer than it really is. And the banks are slow. They don't reply. They give you a response 2 months later. What did you want again?
Yeah, that's right.
It happens. I swear, I get a text that you sent a request, but our department doesn't know what you want. What department are you from? Anyways, here's another thing too. Now, once the probate is issued, now the executor has the power to, distribute. It doesn't happen right away. Now, there is a 210 days after the grant period, which is a wait time for challenges for people who are beneficiaries out there who disagree with the way the things are supposed to be distributed, or maybe the executor is going to plan to sell the house and divide the assets, but the one of the beneficiaries doesn't want to sell the house, or the reverse happens where they want to keep the house, but the beneficiary wants to sell the house. I don't want a piece of property. I want the money. I need the money now. So these things happen. So there's a time frame to allow for any claims to be filed and served, and that's 210 days after the grant of probate. Now you can get the consents of all the beneficiaries, and then you can do your transfer before 210 days. But then you have to get all these people to agree if there's a lot. Maybe it's just one or two, but it's still a process that's there. Now you add that on top of what Kit was saying, you have to wait so long if you have to go through a will to give your assets. So now I add that 210 days on top of the other, right? So the whole point is trying to say, well, do you want to do this? And for me, when I do estate planning, will is the backup to the backup to the backup, and you plan everything ahead of time. Do everything you can that you can control, and if it's something you can't control, then you leave that for the will to take care of. So that's my plan when it comes to estate planning. Okay. A little bit about the cost. We mentioned a little bit about it. Okay. Probate fees, legal fees, transfer fees. In the context of real estate, it's really important. Okay, because many people may not know this, but here, let's go here. Cost of probate fees are a sliding scale. You have a sense of how much you have to pay. So when you give money to, life insurance, there's no fee. You pay the premium, yes, but at the time of transferring, there's nothing to be paid in order to give. Now, probate, you have to pay in order to give. So, and in fact, what you end up giving is less because you have to pay for all these fees upfront in order to pay to distribute to the children, right? So anything up to 25,000 is free. There's no probate fees. There's still other kinds of fees, but there's no probate fees. Between 25,000 to 50,000 is $6 per 1,000. And anything over 50,000 for every $1,000 is $14 plus 150. So you're looking at this like it's approximately 1.4% anything. Okay, so that's a good thing. And this cost applies even if there's no will. So I didn't mention about the administration process, but everything is the same. You still have to search for a will, prove that there's no will, and then search for assets, and then search for potential beneficiaries and notify them and that you're applying to be the administrator for the person who passed away and notify. So the same process, same fees apply, whether you have a will or not. Okay. Another thing too, I just put this here because you have other things if you have real estate. And it's going to give the property through real estate through a will rather than through joint tenancy. So this is where you compare to what we said before. Legal fees for the probate, anywhere on average, anywhere from 3,000 to 7,000. Okay, this is for all the process and doing all the forms and filing and everything like that. Then for real estate, before a real estate asset can be distributed, it has to be transferred into the name of the executor or the administrator. There's a whole transfer fee and land title office and a lot of forms to put it into the name of the executor. So there's anywhere from 600,000 based on what type of land, is strata, a condo, a home, a leasehold land, First Nations land. There's procedures and protocols and land title transfer. So that's not only the fee for the probate, then fees to do the transfer to the executor. And then you transfer the property from the person who's executor to the beneficiaries. If they're going to do the transfer of title, then it's another set of fees to the beneficiaries. Add their names on title. Do they want joint tenancy, tenancy in common, what share? And then, sorry, a little typo here in terms of the capital. But then if it's an investment property, on top of that, there's property transfer tax. I just mentioned 1% of the first 2% of the rest. If it's a principal residence, it's fine. But if there's an investment property there, then you're looking at extra PTT on top. And then if it's a property that is investment and sold, and of course it's deemed to be transferred at the time of death, there's capital gains tax as well on top. So you have all of these things that could be taxed if you just give property through a will. This is real estate through a will potentially, and all the different costs. So it adds up. You put all these things together. It's not just cost of probate, it's all these things as well. So you have a good sense of, and capital gains, is based on what, there's a lot of things to calculate, but generally you get the appreciation from the time it was purchased or transferred into the name of the person who passed away until the time they passed away, and then the value between, and then 50% of that gain, then you add the entirety of the amount to the person's income who's a beneficiary. And then what that person has to pay is income tax on that amount, which can be a lot. I have clients that had a house for 30 years and they bought it for, 200 grand. It's now 2.3 million. Think about 50% of 1.8 million, which is $900,000, and then paying taxes if you're a millionaire earning $900,000 that year. You think of your tax bracket, that's like almost $400,000 and $450,000. You really don't get a lot back. So, not quite a lot. Okay. So here's a sample estate, total $6.3 million, probate fees, $87,650, property transfer tax, $68,000. Then if you do the 8, capital gains tax, pretending that, there was a $500,000 gain, which is very modest, $250,000 added to income tax there, and then you take that tax, whatever the person's tax bracket is. Okay, so that's all on that's not talking about legal costs and all that too, but just a nice little sample so you can see some of the numbers. Okay, so that's my presentation for today. Here's my information again if you want to scan. That's my WeChat, but I don't have my WhatsApp. My email is not actually itlawcorp, it's iventse.com, just right there. There's my website right there. So thank you very much. Oh, you're on mute.
And let Ivan hear the tapping. Okay, thank you, Ivan. Now, does anyone have any questions at this point? Hello?
Yes,
Sleeping? I thought that's quite fascinating, even though I deal with this a lot.
Rose, yeah. You can do Rose first, maybe, yeah.
Yeah, okay, Rose.
Oh, hi.
Go ahead, Rose.
Yeah, my question is like, if you have property in overseas, so should you have another will in the overseas?
Yeah, my answer to that is yes. You get different answers because you can try to get a will that's done here and proven to be applicable to another jurisdiction. But you never know what the laws and rules are from another jurisdiction. For example, I gave you that earlier example, but before 2014, the laws changed and there's certain presumptions. So I would tell anyone who has assets in another jurisdiction like Hong Kong to do a will in Hong Kong that deals with the assets in Hong Kong. So because they have different rules. So if you say something here, it may be applicable because of the laws here, right? You can do it, but the problem I've had many times, for example, I had a client that did a will in Hong Kong and they have property here in Vancouver. And when they brought the will over, I said, well, the name on the will doesn't match the name on title. The last names are reversed. Okay. The land title office says it's got to match, that the name of the will has to match the name on the title, or else a different person. Now, when that happened, they already got a grant of probate in Hong Kong. Then they came here to try to use the same, the grant here, but they can't. And the only thing I could have asked a lawyer in Hong Kong, can you go get an amendment to the proceedings in Hong Kong to put also known as, you can do also known as, and have different names, and maybe then it may work. But yeah, so anyways, the short answer to that is yes, but I don't advise it. The better answer is do a will wherever you may have assets, and it doesn't matter here in Canada as well. One in Alberta, something in Toronto, something in Hong Kong. Do a will in each place so that it applies to the will legislation in that place. Okay.
I see. So what if let's say you sell the property and then you have to redo the will again?
No, here's the thing. That was the first question that may came up at the beginning. You may have a will that's valid, but it's ineffective. So I would never usually try to advise that a client put a specific property, unless there's things such as heirlooms, things that you want to hand down to your daughter or kid. This is my wedding gown. This is my ring from my grandmother. Things that maybe not likely to be sold, like a house is sold and bought, and cars are sold and bought, and things that you can put those in the will. But I won't usually advise to put specific assets in a will. I would normally say, and this is the structure of the will that I usually prepare. First of all, the executor first of all locates and searches all of the assets. Secondly, pays all the debts and anything owing. The leftover is called the residue. And then I usually say the residue is divided up into X number of shares. If it's 3 kids, then 3 equal shares. 1 share to each kid, and one of the kid passes away, their share gets divided into their kids equally. But if that kid has no kids themselves, so no, from the testator's perspective, no grandchildren, then it goes to the remaining siblings, and vice versa. So you have several different levels all taken care of in the will, but you don't say specific assets, and it's allowing the executor to make the decision of how to divide the assets equally. If it's like, for example, 3 kids, 1/3, 1/3, 1/3, the executor is now in control. There's a house, there's a condo, there's a Bentley. Okay, well, each one is equal the same, so I'll give each of those kids one, and it's all equal. Or sell it all and split the money equally. It's still at the end equal, but the executor uses his discretion or her discretion to divide it up, pay the will without specifying. And I do see addresses, and I see that all the time, and it's not that it's wrong, but it's likely to be ineffective at some point. Yeah. So sometimes when you have younger children, and there's a potential for more children later on, depending on the age, right? That you have seniors, you're not going to have any more kids. So when you're younger, then you have a will that can grow and doesn't have to be changed all the time. You can say, to all my children, then living equally. So my nephews and nieces, then living equally, no matter how many nephews and nieces there are, it's all equal. Sometimes it gets difficult if there's like blended families, and is the nephew and niece of your ex-wife still a nephew and niece?
So Ivan, basically you're saying that don't put a specific address of a property, just say whatever property under my name will be distributed like that, right?
Exactly.
Yeah. Actually, after listening to Ivan tonight, I'm thinking almost like, I'm not going to buy a house. Or just, if anything to distribute, cash probably is better than, trying to deal with a house, almost.
Yeah. Well, procedurally, wise, in terms of transferring something, and I think traditionally Chinese, they like money, but I mean assets like properties, right? And usually they go up in price, but it is not liquid. It's not liquided. It's not like a beneficiary under TSFA. It's different than an investment account. You don't have to go through that. Death certificate, bam, you can distribute right away. So
now I do have one thing that I want to ask, very important and interesting that you mentioned, because of all the taxes, the probate, like even if you want to sell the house, there's a lot of taxes, to capital gain to be paid, right? What if the person cannot come up with the money? Like, which one happened first? Because like they need the money in order to pay the taxes, but if they don't sell the houses, they don't have money. So
that is a real
have you
turn,
what will happen then if the person cannot, because they didn't have a life insurance, they cannot come up with the money, then what?
Well, unfortunately, assets get inherited as well as the debts, right? And I had a situation where the children just didn't have enough money to pay the capital gains if they had sold the house. And so you know what they did? They didn't sell the house. They didn't even transfer it. They didn't even do the probate. They just let it sit. and taxes come and they pay their taxes, but they never ever did any transfer, and they never applied for the probate until the time they got a buyer comes along with enough money to pay, in order to use the money that they're going to get paid from in order to turn around and then pay the taxes.
I see.
So yeah, 15 years later, the value went up like 400 grand from the original.
So it's enough to pay the taxes.
Okay, it's time now. And then they do it, and then they had enough. But unfortunately, some people that, geez, it's too expensive for me to even probate, so don't even bother.
Yeah, I actually have a guest here in our audience, or participant. Gary is actually an accountant, and he has we talked earlier. He has a similar story about what happened if you bank on my property is going to be to make my family rich, so they don't need my help, right? Gary, do you mind sharing that with us? Oops.
Oh, sure.
Where did he go? Oh, there he is. He disappeared. Yeah.
Yeah.
Went from the top to the bottom to the top. It's like...
I actually also have a client coming to our firm, like asking help, like after during COVID, they actually lived in the house, but unfortunately their parent passed away during COVID, and they did not have enough cash flow to pay the income tax and the lawyer fees, the professional fees that's necessary to inherit this house. So they decided to do nothing, just like what Ivan said. Yeah, it happens like quite often actually, because like income tax, like sometimes when it goes up to like 200K, you need to pay like 52% on personal tax side. So not everyone has that cash flow to pay on the income tax in order to get the notice of assessment from CRA, which is required to process the probate.
Now, okay, let me see if I can. Will it is
you can have the power to mute.
Yeah.
Okay, you have the power to mute.
Okay, how do I mute everybody? Okay, brilliant. Now I have a question for either gentleman, whoever can answer. So these people, they cannot come up with the money to actually pay for the capital gain, but did they actually inherit the house then? Because the house in the will was supposed to be like, okay, you guys can sell the house and get the money, but so legally, does the house still did they inherit the property, or is the property is in limbo? Nobody knows what to do, and it doesn't belong to anyone at that point. And who will be responsible?
If I can do the first stab at it, the first thing when it comes to legally is the probate fees. They don't have to pay capital gains at the time of transfer. It's when they sell the house, and it's not at that time that it becomes due and payable, and so we can still do the transfer of the home, do the probate, pay the probate fees, do the transfer of the home into the ownership in the name of the people who are beneficiaries. Then when they have to, file their tax, the tax returns, and that's when they have to deal with it. Okay, so they can actually legally own, but then they have things that are owed and how to pay it. Now that they legally own it, they can turn around and try to sell it. Right. So, and then now, Gary, maybe you have the other part to it in terms of.
Yeah, so and that case, like a couple of the clients, they couldn't get the notice of assessment because they didn't really clean up the tax. There is a deemed disposition, just like what Ivan said, like all their assets is deemed to be sold at fair market value. So not only the property, but also all their investment, like stock, they are deemed to be sold at fair market value. So that family was not able to pay all the balance owing to the CRA, and there was a consequence that they actually couldn't inherit that house, in my case. Yeah, so they continue to live in that house, but there are actually issues because they don't own that house. There are utilities issues from strata because it's not under their name. Yeah.
So they became the squatter of their parents' house. Wow, that's amazing. So if, well, at least they could still stay there, right? But they better start looking for a place to stay somewhere else, right?
I
Until
think
they fix
the
that.
issue is that who has the right to kick them out? You know, they're there, but who's going to apply? Who's going to apply to take over and seize, and who's going to do that, right? So,
well, that's another story, another day, another webinar, I guess. So if our guests here don't have any other question, I guess. Oh, hang on. Besides life insurance, what other way to simplify the probate?
yeah,
Okay, maybe.
like I mentioned, having properties held as joint tenants, joint ownership, that avoids the probate right there. Death certificate at a few forms, and then it transfers to the survivor. Land title, same thing, not that difficult, maybe about $1,000 in fees, but that's about it. You've got death certificate, PTT transfer form, Transparency Act form, and a few other documents, and then it transfers to the ownership without having to go through probate. So, then life insurance, there's designated beneficiaries under certain investments, segregated funds, and the Kit can tell you more, but these are all money vehicles. Like I said to the one guy who was going to give a house to one of the kid, and kid number 7 that the 6 other ones didn't know about, he got life insurance, so he doesn't have to transfer real estate to them.
Yeah, and Olivia, yes, Ivan has lots of YouTube video on his website, so you could go to his website and search whatever topic you are interested in.
Just search Iven Tse, my first and last name. You don't need to do my initials or anything. And then better yet, if you can click like and subscribe. But then there's like a whole bunch of topics. I do a lot of presentations like this, real estate wise. There's one in particular called in collaboration with the Chinese Real Estate Professionals Association. It's the June of last year, and it's all about real estate and estate planning. So look it up, and you'll see lots of points.
Yeah. So obviously, thank you for joining us tonight. If you have any questions about anything around wills, around tax planning, Gary is a really great person to go to. We all want to pay least amount of taxes, right? Because we don't want government to dip into our pocket even the day we die, right? So planning, doing things ahead is always a good idea. And so that's why you also need a will. And again, life insurance, segregated funds will be a really good vehicle, to help you to, if you feel like me now, like maybe getting a property, owning a property is not necessarily the easiest way to transfer your asset, then there are other vehicles that is available as well. Yeah. Let me see if
you get the life insurance there, the planning here, and get the accounting tax advice over there.
Exactly. Yeah, Gary will. If I also would invite you to like my Facebook pages and subscribe to my newsletter as well. It's always lots of information. And so Gary will be my accounting partner. I'm actually forcing him now. Like he hasn't actually said yes yet, but now he is.
So we will. It's like a proposal.
Will you marry me? Yeah. So and Ivan's video is it in Cantonese, Ivan?
There's a whole bunch. There's some in English and some in Chinese. They're both languages, and it depends. And all the radio shows are all Cantonese. So the radio segments are all in Cantonese, and then the rest are all varied between English and Chinese.
And we are all professional here, so that we all have the same philosophy. We want to do the best for the clients, and help them to find the best solutions. So if we look forward to seeing you in the future for our other webinars. We have one coming up quite soon, I believe. And then I will definitely announce it and through the email, the newsletter. I hope you will sign up for our newsletter as well. So any more questions before we say goodbye for the night? No? Okay. So have a good night, everyone. And we'll see you next time. Thank you. Thank you, Ivan. Thank you, Gary.
Thank you.
Thank you, everyone.
Thank you, everybody. Thank you.
Good night.
Take care.
Bye.
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 Bye.